Good morning and welcome to the first panel session, Preparing for the Mother of All Trials. The world watches international trials with great interest and intrigue, none more so than the trial of former Iraqi President Saddam Hussein. The Dujail Trial with Saddam and his co-accused is about a crackdown launched against the town of Dujail following a 1982 assassination attempt on the president. Hussein has admitted that he ordered the trial of the 148 before his revolutionary court. But he said he had the right to do so because they were accused in the attempt to kill him. They were all executed. It is interesting to look at the establishment of the ICTY and ICTR over a decade ago, which highlighted some challenges that exist in preparing for trials of this magnitude. The subsequent hybrid tribunals benefited from the experiences of these early courts, as will future tribunals. As coordinator for one of the newest trials at the ICTR, the case of the famous Rwandan singer Simone Bikindi, I have spent months working with all stakeholders to prepare for a trial, which began on 18th of September. However, working within the confines of the ICTR, an established tribunal, I have been spared many of the obstacles which face those at the Iraqi High Criminal Court. Preparing for a trial of this magnitude involves more than meets the eye. Even before the invasion of Iraq, the idea for a court to deal with the crimes of the Saddam Hussein regime existed. This trial can trace its origins from the preliminary drafting of the statute to the investigations to the creation of the Regime Crimes Liaison Office. Many actors have been involved in different components of this newest international criminal justice mechanism. In deciding how to proceed with the Iraqi court, these actors have had to make many choices and weigh different options in a relatively short period of time. Compared to the lengthy preparation time taken for the establishment of the ad hoc tribunals, this has been a remarkable challenge. We have a phenomenal panel to discuss and debate the issues in preparing for the mother of all trials. Some of the factors that need to be addressed in preparing for a trial include the type of court to create, whether to create an international tribunal, a hybrid tribunal, or a national court, how to establish a legal and legitimate Iraqi court when there's a foreign occupying power in Iraq, the decision not to combine a tribunal with other mechanisms such as a truth commission and a victim compensation scheme, the challenges of training the judges and prosecutors, deciding which cases to prosecute, and the resulting challenges of recording the full extent of the crimes committed, deciding on the ultimate punishment, a death sentence, and the challenge of operating a court in the midst of civil conflict, how to protect witnesses, counsel, and judges. These are some of the issues that can be discussed, and I will ask our panelists to speak, and then we'll open the floor to questions. And we'll start first with Professor Bassiouni.
Well, thank you, Christopher. You have given us an excellent summary, and we caucused a little bit before the beginning of the panel, and they all kindly agreed to allow me the role of the bad guy, which is the one who is going to raise questions. First, let me call your attention to the fact that whenever one tries to establish a new enterprise, it is really fraught with many difficulties. And it is so much easier after the fact to look back and say, well, really they should have done this or should have done that. So, in a sense, bear in mind that the luxury of hindsight is something that should not always be taken for granted, and that we really have to keep in mind that we had a very fast-moving situation at the time. The decision for the United States to militarily intervene in Iraq is one that, as you know, was fraught with all sorts of political perils and uncertainties, and as a result, there was a determination on the part of the administration to go ahead and do it. And if you look at the various priorities that the administration had in going to war, my guess is that justice was probably not among the highest priorities. In fact, you know, there wasn't even enough thought being given to the administration of the country, to post-conflict justice, to rebuilding the economy, to administer the country after the conflict itself. So there were just so many competing interests at stake. One of which was, of course, the internal political struggle that was going on that you all know about, and it's a matter of public record, between the Department of State, DOD, which agency is going to be responsible. National Security Advisor Rice decides the Department of Justice should then have a role with respect to post-conflict justice issues. So all of the work that was done in the Future of Iraq project, the Working Group on Justice, wasn't really passed on, and so there was a loss of an enormous amount of work and expertise that could have benefited. Again, with all due respect to the Department of Justice and those who have, as of recent, really worked in the field of getting involved with providing training and technical legal assistance to foreign legal system, this is not one of the primary missions of the Department of Justice, and while they've done a great job at it, it was something new, and a lot of people were pulled from left and right. People who were prosecutors and judges in different areas of the country were brought to provide their expertise. And so it developed as a program in which the U.S. was, in a sense, exporting its technical legal assistance, its knowledge. It was not a program in which the U.S. was acquiring knowledge of the foreign legal system and then saying, okay, what is it that I can do to fix the system? Let me give you an example. I'm presently directing a project in Iraq which is to establish a comprehensive strategic plan for the future of the justice system. And the first thing I did was to invite the Chief Justice, the Minister of Justice, and all of the stakeholders to a series of meetings. We've already had 2 meetings, to tell me what they want. And then I would see how I can provide the assistance. I think at the beginning there was a bit of the assumption that maybe the Iraq infrastructure was crumbling entirely. As the ambassador said, there were a lot of people who had no idea that Iraq had a legal system. And so everybody was quite willing and eager to export their knowledge, but without really due regard to understanding the Iraqi system. So that caused a little bit of difficulty. So you had a certain political dimension, you had a lack of clear understanding, except when people went there and started working in the field, like Chris and Greg and others. You know, suddenly they, of course, understood. But before they went there, they didn't come from that background. In other words, in our Department of Justice, just as in our Department of State, we don't have experts in comparative legal systems. People learn that as they go along in the business. There was a big political issue at one time. You know, do we have an international tribunal? Do we have a mixed tribunal? Or do we have a national tribunal? I have always been in favor, as were all of my colleagues, 41 judges and lawyers from Iraq, on the Working Group on Justice, that it should be a national legal system. We were all confident that Iraq had a national legal tradition, that it had the judges, that it had the capabilities, but above all, we all believed Iraq had to take ownership of that project. It took some time until those, and I know Sandy being on the CPA side, and Chris and Greg Kehoe and others who followed, once they went in the field, they subscribed to that view. They understood this is not going to work out if it's going to be an American gift package wrapped up and handed on a silver platter, that the local folks are going to have to take ownership of it. And that means that they're going to have to learn very fast on what to do. The problem was the reconciliation between a certain adversary accusatorial approach to trials and an essentially inquisitorial approach which the Iraq legal system was, modeled in part after the Egyptian and the French system, where you have a judge of instruction who's driving the investigation with a very limited role for the prosecutor, with really no defense rights at the pretrial stage, and so on. So what the drafters of the statute, mostly people from the Department of Justice, working with a few Iraqis, particularly Salim Shalabi, who was on our original working group on justice, but Salim, who chaired the group, was a commercial lawyer who had really no knowledge of criminal justice, and he at the time didn't really know Arabic very well. He had spent all of his life abroad, so it was not a good choice, frankly. So he did his best to reconcile American conceptions with the very little he knew of the Iraqi conceptions, frankly, and it just doesn't mesh too well. My own feeling is that, you know, the Iraqi Criminal Code of 1969 had all of these crimes. The Iraqi Code of Criminal Procedure could have passed muster. After all, it's no different than most of the inquisitorial systems of the world. Why reinvent the wheel? Why do a statute in which we're going to have definitions of crimes coming from the ICC statute? It's a problem. Two-thirds of the countries of the world are positivistic legal system, in which you do not have a crime unless the criminal law states it is. I mean, this goes to England. If you went to England and we said, you know, we want to apply the definition of crimes under the ICC, they will tell you, I'm sorry, it's not part of an act of parliament, you can't apply it. Don't tell me it's jus cogens or customary international law. Same thing goes for Germany, most European countries. You know, the Iraqi legal system follows that, so it was difficult. We could have gotten by with the war crimes because there was a military code which had adopted many of the provisions similar to the Geneva Conventions. Iraq had signed a few international conventions. We could have latched on to it, but ultimately, in my judgment, we should have linked those to the crimes which were in the criminal code, and that would have been so much easier and so much better. It would have avoided all of the problems that we had on ex post facto and obviously legitimacy of the crime applicable. Again, I would have gone with the Iraq Code of Criminal Procedure of 1971. I know that there was this urge on the part of the Department of Justice and the U.S. to make this thing look good, that Saddam would have a fair trial. But, you know, I mean, if the Code of Criminal Procedure was good for the rest of the Iraqi people, frankly, it should have been good enough for Saddam and his cronies as well. There was really no reason to start introducing notions of confrontation and cross-examination, which is something that never existed in the Iraqi legal system. So this all caused a bit of confusion. Gathering the evidence also caused a little bit of confusion. The U.S. came in with the best of intentions, providing all of the necessary resources, but necessarily it meant that it was carrying the load. It was doing the work. So for a long period of time, it was not an Iraqi project. It was an American project in which the United States was looking for Iraqis to gradually come into it, gradually learn, gradually become part of the process. There was an exigency to it, and there was time. If the U.S. was going to wait until the Iraqis would get their judicial house in order and their legal system up and running, it would have been 2-3 years, and there was a question of time that had to go into the whole process. So that was also a factor that had to take place. So the bottom line is there are a lot of technical legal issues which go to the legitimacy first of the statute called the IST. Then it was amended, as you recall, October of last year. The amendment, in my opinion, did not cure many of the problems. One of the technical legal problems, again, as jurists we speak, is that the new statute abrogates the old statute, and yet at the same time says that everything done under the old statute is valid, Well, you have a contradiction. If you've abrogated something because it doesn't have the proper foundation of legitimacy, then what was done under it is not, obviously cannot be considered as legitimate. In my opinion, the new statute should have abrogated the first, and then simultaneously with that, new proceedings should have started. So I would have issued immediately a new indictment, new appointment of judges, everything new as of the new law, so as not to have the question of whether the prior one was or was not good. Two final questions. I'm going to abuse my time by 1 minute only. Two questions of great importance. One, I don't think there is ever in history a major trial like that one, or even domestically, that didn't have its share of problems. So to think that you're going to have an ideal case like this is absurd. So the question is whether the share of problems that this case has had, is a reasonable one, is part of the baggage of having to deal with a highly politicized, highly visible case and an obstreperous defendant. In my judgment is yes. I don't know why a lot of people are so exercised by the fact that Saddam Hussein sometimes runs wild with the proceedings. I think that's to be expected. And frankly, I don't think that's a big deal. And if a judge gets mad and tells him to shut up, that happens every day in every courtroom in every country in the world where you have an obstreperous defendant. So that's not the hallmark of due process and fairness. What would be important is, did he have access to the evidence? Could he prepare his defense? Did he have access to his counsel? That's what's important, not the antics that you see at the trial. And the most important thing is, what do the Iraqi people feel? And then, what do the Arab people feel? Do the Iraqi people feel there is justice? Do the Iraqi people feel there is a value in having a trial like this which brings out the evidence, or would it have just been better to just shoot him when he came out of the hole and forget about it? Which I think most of the people think that's the case. And in the Arab world, as the ambassador said, if nothing else, it established a precedent. It establishes a precedent that tyrants like Saddam Hussein will have their day in court. It may not be a perfect day in court, but tyrants of the world beware, tyrants of the Arab world beware, and this in and of itself is certainly worth a great deal. Thank you.
Thank you, Professor. Christopher Reid.
Thank you very much, and thanks for your remarks, Professor Bassiouni. We hear a lot of criticism of the process in Iraq that it doesn't look international enough. A lot of people want it to look more like the ICTY or other international tribunals. And we've heard the opposing view here today, which is that the statute looks too much like the statute of the ICC and is too international. And I think a balance has been struck. Let me just tell you a little bit. Sandy Hodgkinson was in Iraq during the CPA days, so she can address some of the early issues that the professor has talked about. And Mike Newton also worked on some of the statutory issues. While I arrived in Iraq in March of 2004 and stayed until the end of 2005, my early time was not involved in this. I went up north and worked on the investigation of the Anfal case. So I was up in the Kurdish region working with in particular two Iraqi investigative judges and their investigators on gathering evidence about the Anfal case. And just as Professor Bassiouni was mentioning earlier about his work on his commission, there was a lot of press reports, and international groups, Human Rights Watch and others, had done a lot of reporting on the Anfal campaign and other crimes by Saddam Hussein. But that's not evidence. You really have to go out and gather the evidence yourself, and you have to gather evidence that will stand up in court. And so that was my role up there. But when I came back to the embassy in 2005, I had a leadership role as the Deputy Regime Crimes Liaison and later as the Regime Crimes Liaison. And the Regime Crimes Liaison's office role is to be the lead office in the embassy for supporting the Iraqi government and the Iraqi High Tribunal in everything that has to do with the investigation trial of Saddam Hussein and other regime members for possible charges of genocide, crimes against humanity, and war crimes. And always, when we went about this work, we're looking for, a few things. Obviously, justice for the victims and fairness to the defendants is very important, and a perception that there is justice for the victims and fairness to the defendants. Promotion of the rule of law is important. And you promote the rule of law two ways. One, as the ambassador was talking about, is letting the Iraqis work out some of these issues for themselves by going through this process of having this very important trial, and also by having the Iraqi people see what, justice being done, even for someone as, hated really and reviled by the Iraqi people. Also help Iraq come to terms with its past and create a record, a permanent record of what went on, so that in the future people can't deny the crimes that took place in Iraq, and they were many and horrible. I, during my time investigating the Anfal case, stood in mass graves that were all women and children. One mass grave, 130 women and children, all with small caliber bullet holes to the head, including infant shot while at her mother's breast. And it's basically one woman for every 4 or 5 children, and it's just women's bodies with little feet, with their little rubber and plastic shoes that the Kurdish children wear, sticking up in every direction. And then going into the villages and talking to the family members and saying, what happened when this happened, and having the people tell their story, which is a very important part of the healing process, tell their story to an Iraqi investigative judge. And my first job when I got back to Baghdad, the most pressing issue was there were lots of press reports that Saddam Hussein was being denied access to his defense attorneys. And I think it's a good anecdote to tell, because it will tell you a little bit about what really goes on compared to what you hear. The press reports over and over again, there were attorneys all over the world saying that they had been denied access to their client, Saddam Hussein. And Saddam Hussein had been meeting with his attorney in Iraq, and this issue just wasn't coming up in Iraq. And there were attorneys who we had just never heard of who were saying, I represent Saddam Hussein and I don't have access to him. There was one attorney who we'd never heard of who said, I represent Saddam Hussein and I've been seeing him regularly, and we had no idea what he was talking about. So Judge Reid, the chief investigative judge, sat down with Saddam Hussein and said, this is Mr. Delaney, he's your attorney. Are you happy with him? Oh yeah, I'm very happy with him. You can have other people represent you. You can have international experts. You can have whoever you want represent you, as long as they work with Mr. Delaney and follow Iraqi law. It's up to him. He's my attorney. I trust his judgment, whatever he wants to do. I will go along with it. Let us know. And so the judge talked to the defense attorney. This is what you need to do to get other attorneys registered. I don't know why you haven't done it yet, but talk to your client, talk to these other attorneys. But I, as a judge, Judge Reid said, have to listen to you and your attorney in front of me, not these press reports and other things that I hear. But the stories continued, I think that just sort of gives you an idea of some of what the IHT was up against. And the other thing is that it had to be, the whole process had to be open and transparent. And the open and transparency helps with the coming to terms with the past, creating a record that everyone can see, making sure that people understand that the proceedings are fair, and promoting the rule of law in Iraq. Now, an issue that came up early and late was whether or not there should be an international tribunal. And as those of you who work in this area know, if the national courts are willing and able to conduct a trial of these kind of crimes, and that is the preferred jurisdiction. And there's good reasons for that. If you look at what you're trying to do, having an outside institution somewhere else in the world, having a trial that doesn't really seem familiar to the Iraqi people isn't going to meet some of these goals. And I'd say that that's particularly a problem in a place like Iraq, which doesn't trust some of the Western institutions, does not have a history of that. And also, the Iraqi people, I don't think, wanted to feel like there was a trial of Iraq going on, but rather the Iraqi people getting justice from criminals who had committed crimes against the Iraqi people. And so I think that's the choice that was made. I wasn't involved in that, and I think these two can talk a bit about working with the Iraqi government on the statute. But later on, the National Assembly, which was democratically elected in Iraq, looked at the statute and made some changes, but basically kept most of the statute as it was, and affirmed the decisions of the court previously and the judges that were there. So this question of whether or not it was an interim government during an occupation really was put to rest by that act. And I think that the Transitional National Assembly made some good, they made some good decisions, that some of which we agreed with, some of which we didn't, but they really did take a hard look at the statute, and I think that that they understood that trying to start afresh was not the way that they wanted to go. They made a considered judgment that they didn't want to start afresh, that they would, even though some of these judges had been appointed previously by previous government, they wanted to keep a continuity. And I think that having a continuity of the judges is something that this country didn't learn until, a few decades into our history. Really understand that we should have that. So we worked very closely with the Iraqi High Tribunal. Part of our job was like the Iraqi Reconstruction and Management Office's job with respect to other institutions. It was institution building, coordinating training, coordinating translation of international legal texts into Arabic for the first time, helping to build the courthouse, security issues, which we understood to be very important. When we looked at sort of how we were going to do things and whether or not the things that we did made sense, a couple of phrases often came to mind. One was first, do no harm. This is an Iraqi process. The Iraqis have to make these decisions. We shouldn't be imposing our point of view, and we should be very careful not to be, doing harm to the process. And the second one was when we would have discussions about how to do things and whether this was the right way to go. Compared to what? When you talk about the length of time it takes to prepare the case, you have to say compared to what? Compared to a complicated federal case in the United States? When you talk about the procedures that the Iraqis are put in place, and there's a catch-all provision that does refer to the procedural code, and they do look to that in many cases, you have to say compared to what? And as Westerners, especially from this American or British legal point of view, we've got to remember that this is not our adversarial system. This is an inquisitive system. That's the system that's going to be familiar to Iraqis. And when the government of Saddam Hussein wasn't interfering with it, it's a system that was working pretty well. And there were very well-educated lawyers and judges in Iraq, educated at universities like Baghdad University, and they were available and willing and to do the work. And I think that they've done a pretty good job under tremendous pressure. And I think we should really remember that they are operating in a very difficult environment. These are people who understand the importance of the rule of law. They understand the importance of democracy. They're risking their lives every day to bring to Iraq things that we really take for granted. And sometimes when I hear people talking about whether the Iraqis can really do justice, it reminds me of some of the talk before the elections. The Iraqi people, they don't have experience with democracy, they are not going to understand it. But when we watched the elections, they understood what they were doing. And being on the ground in Baghdad and talking to regular Iraqi people, I can tell you that they understood democracy, and they understood what it was that they were doing when they went to vote in a way that's so much more vivid and real to them than it is to many Americans, because they were risking their lives for it, and they'd lived under tyranny for so long. They do get it. And they get why the rule of law is important. On a day-to-day basis, people may get frustrated and say, gosh, I wish they'd just take him out and shoot him. But I think in the long term, the Iraqi people are going to be very proud of the fact that they struggled with this, and they have struggled with it, and that they've put together a court, and that court has done, really, I think, an excellent job of making sure that they have met some of these goals that I talked about in terms of the rule of law. And just, in closing my remarks, and we'll talk a little bit more about this in a few minutes, I want to talk about something the professor referred to in his earlier remarks about trying to prevent future atrocities. And, when you do this work, people ask you, or you ask yourselves often, well, we had Nuremberg, but now we've had Yugoslavia, and we've had Bosnia, and we've had Rwanda, and we've had the genocide that took place in Iraq in the late 80s. So does it matter? Is it helping that we do this? And I really think it does, and I've got some concrete evidence that it does. When you look at some of the documents of the Saddam regime during this genocidal campaign against the Kurds in the north, there are some times where you can see from the documents that some leaders of the regime thought, boy, we might be held to account someday for what we've done. And so they say things like, from now on, don't say General so-and-so or this person ordered this act to be done. Just say, it's been ordered. So they do recognize that maybe someday we're going to be held to account. And I think that does mean that maybe the genocide wasn't as large as it would be. Maybe it ended a little bit sooner than it would have. And the amnesty, you know, Saddam's amnesty at the end of the Anfal was for everyone but Jalal Talabani. And he's obsessed with the fact, I think, that President Talabani is now the president of Iraq. He always mentions it. And when his brother, Barzan al-Chakriti, half-brother, said, you know, I've written to President Talabani, Saddam turned around and said, I'm the president. What are you talking about? But I think that it did affect their behavior. And I think that there were other tyrants around the world who, in October of 2005, when a witness, an ordinary Iraqi from Dujail, stood up and pointed his finger at Saddam. And I was in the court then in the observation gallery. And it just by accident, I had walked in to, you know, say hello to someone and see how things were going up there. And just at that moment, and this man, he points and he says, you're the one who did this. You're the one who did this to my family. And everyone, you know, knew that something like this was going to happen, but still everyone gasped. And I think there might be dictators around the world who saw that moment, saw Saddam Hussein being brought to justice by his own people, and they may have gasped as well.
Thank you.
Thanks, Whisper. Sandra Hodgkinson.
Good morning, Ambassador, esteemed colleagues, and ladies and gentlemen. Given that you can see many of us have overlapped over the past several years in our efforts, I'll try not to repeat sort of what my colleagues have talked about, but there will be a few things where I'll sort of want to give a personal perspective as well. I've had the opportunity to work on this on and off in a variety of contexts since 2000, when we first provided some training under the Iraqi Liberation Act for members of the Iraqi opposition who were seeking training in war crimes. And Mike Newton joined me in that back then, and it sort of began what was a long struggle towards where the trials moved to today. I've had the pleasure of working on the Future of Iraq Working Group on Transitional Justice through the State Department prior to going out to Baghdad, and then also serving as the first senior advisor on human rights for a year in Iraq, departing just about a week, I think, before my colleague Chris arrived. But throughout the process, and I've continued to work on it now at the State Department's War Crimes Office and previously on the National Security Council, this has been a tremendous undertaking. And, you know, I don't think I can personally underscore the dedication of the Iraqis who have been participating from the beginning and the hard efforts it takes in sort of, you know, being in the situation where you have personally suffered and your family has suffered and your country has suffered. And yet everybody seems to have a way to tell you how to fix it. And particularly in this field, for those of you who work a lot in war crimes areas, there isn't one size fits all. And I think we're recognizing this as we move forward. And the lack of a one size fits all means that you will get differing advice. And many people whose advice wasn't accepted get frustrated with the process. And that's something that becomes difficult in building consensus and building support. So, you know, certainly it's important in this light to think of, you know, doing the most that we can to try to support the Iraqi people in the decisions they've made on how to take this forward. From sort of the early days out in Iraq, again, I was there from the very beginning when the first mass graves were being opened. You know, you can't describe what it's like to go out there and firsthand see people who have been waiting a decade or 20 years, knowing exactly where it is that they're going to go when they have the chance to do so. And to see mothers and brothers and fathers coming and sort of clutching at remains in the graves. And it's just so powerful, you just can't sort of capture it any other way through history books. But in the early days, there was a lot of more pandemonium, people trying to figure out how are we going to deal with this and what are we going to do. And the Iraqi Governing Council had a tremendous challenge in figuring out how to channel this in the right direction. And this was an important piece. I mean, they had set up a legal subcommittee that worked particularly on drafting this statute and seeking support from internationals, but also, as Iraqis, working to rectify their older codes with modern notions of justice that have been developing and are still developing as we speak. There's also another part of it, though, which was the civil society aspect. And, you know, I had a tremendous opportunity to work with Iraqi human rights organizations establishing themselves for the first time in a long time. And they had views, too, as to how this should be done. And the Iraqis were listening to that. We had, you know, regular working groups on both transitional justice and on human rights, on the broader concepts of what do you do with the mass graves? Do you pay people compensation, or do you have a trial? Should you have a Truth and Reconciliation Commission? Again, it's easy from, you know, our perspective from 10,000 feet to tell them what they should have, but it's their choice, and it was their choice. And the Iraqis were fairly unified in saying, we want justice. And justice was something that was very important. And so justice is what hopefully they'll have in moving forward with this process. But in looking at it from the beginning, there are, even within that context, there were a lot of different views. Some Iraqis thought, you know, 200, 1,000 people should be tried. Other people thought, you know, just the key regime leaders. And obviously for people who've worked in war crimes tribunals, it's very difficult to try large numbers of people and to hold them accountable. Truth and reconciliation, while it's been tremendous in many other post-conflict areas, conjured an image to some people in Iraq as the idea of forgiveness, which some of them weren't quite ready to do. And so while there were broad discussions of truth and reconciliation, there wasn't a real consensus reached as to how you'd go about doing that. There was, however, a great clamoring for a truth-revealing process, which is something that would document the history, not just through the trials and witness testimony and documents, but through the establishment of a documentation project, which the Iraq Foundation and other NGOs, civil society, tried to work with the government to try to form some way of ultimately having a museum of historical record and other ways sort of outside of using the court process to sort of tell the history of what happened in Iraq. A couple of perspectives that I wanted to add in addition to that. I echo Professor Bassiouni's view that domestic tribunal here and what a lot of the Iraqi jurists wanted was probably the right call. I mean, that's what the Iraqis wanted. And our policy, U.S. policy, is certainly to support justice happening local when it's possible. And obviously, it takes making sure that those conditions are met for it to be possible. So to sort of stand on the sidelines and criticize the process or say maybe they aren't trained enough because of the manipulation that Saddam Hussein did to the judges isn't fair. What we should do instead is support their request for training and try to bring international assistance. While it's true that the U.S. has funded some of the efforts to bring experts into Iraq, in the early days when I was there, we had several internationals, and we just had to hire them ourselves through U.S. government money because other countries weren't heeding their request for support for international assistance. And that's something that I think is tragic because other countries do have a closer experience in jurisprudence to the inquisitorial model that they have there than the United States does. But needless to say, other internationals were brought in. There was training conducted by the International Bar Association and ILAC. Other experts have been funded, and other experts have independently provided their support to the tribunal, including a number of experts who were here today who've been really actively supporting through the blog website and otherwise. So the Iraqis have received the assistance they've requested, but at no time has it not become an Iraqi process. It's an Iraqi process from start to finish. They face challenges every day. They're dealing with tough issues of law and fact, but they're doing a good job. And the interesting part is, as you know, you have the ability to watch this on television. Think about how many courts in America you get to watch on television. It doesn't always happen that way. And so here you do get to see every aspect of it. So there are going to be days where there's outbursts, and obviously, it's how the judges comport themselves and whether ultimately they make their decisions based on rule of law. So a couple other really quick thoughts before moving on is a couple of the things in specifically preparing for the Dujail trial that are important to consider at least. You know, one of the things that came up obviously in the context of the Dujail trial from the Iraqi perspective is what kind of a case do you start with? Do you start with the mother of all cases, which would be perhaps the Anfal or the 91 uprising, or depending upon which sector of Iraq you talk to, whatever most affected them? Or do you start with something that's a quicker case, that may be smaller in time but easier to sort of work out any kinks in the process? They made the choice to begin with a case, the Dujail, which some criticized as not significant enough, but nonetheless, it was a significant event. I mean, certainly the deaths of 148 should not go unpunished. But because Saddam Hussein was a defendant in that case, the way that the cases are presented, there are multiple defendants. Obviously, it draw more attention to the case than it might have otherwise had as it worked through the kinks. So obviously that's a consideration in preparing for Dujail and in looking at war crimes tribunals generally is, do you start with a smaller case or do you start with a big case? And every tribunal to date has had a learning process as they've moved along, and that's something that we just need to candidly acknowledge. A couple other things that I would just mention from a U.S. policy perspective in supporting the Iraqis is that we also have encouraged and believed that in the Dujail trial, as well as the others, being as transparent as possible was important. Because again, if this is to serve justice for the Iraqi people and serve as a model for the future of rule of law in Iraq and something to look again back to the great days of the past, then it obviously needed to be visible and witnessed by Iraqis around the country so they could believe it with their own eyes and see it with their own eyes and emulate it in the future. That's been extremely important to see that return to rule of law. Timing was also important. Obviously, there is a sense, considering that there are ongoing hostilities in Iraq, that it's important that this move forward and that there be some sense of justice for what's happened, some sense of reconciliation, some period of closure. And trials can bring that. It's one piece of what brings that, but in Iraq it's a critical piece and it's what the people want. But at no time should expediency be in any way a substitute for ensuring a full and fair defense. And that's been something that the court has been very, very careful about. And they're to the point where you actually have standby counsel for every individual in case their counsel decide not to show up some days, which, as you've watched in the media, their counsel decide not to show up, sometimes even on their closing argument day, which is amazing. So they have really taken tremendous efforts in this system to make sure that there is a full and fair defense. And while there will be challenges and there will be kinks, I think, again, the most important thing that we can do as we move forward is look to them to ask us for support and guidance, and as members of the international community, come to that request, because it's in the Iraqis' interest to move forward from this, but it's in the broader world interest in moving forward from these types of atrocities so that in the future there is a deterrent factor against would-be dictators, and so that there is a sense that justice does prevail wherever you live around the world. And this is something that Iraqis can be really a shining example of. Thank you.
Thank you. Professor Michael Newton.
Thank you, Chris. Well, it is a joy to sit up here with these colleagues, all of whom I have served with, all of whom I know, and all of whom I respect in one way or another. I met Sandy in the fall of 2000 when this project began in one way or another, and it's by sheer coincidence, I assure you, that we both wanted to start in sort of the identical conceptual place. As Cherif pointed out, there's this deep visceral need for those of us who work in this field. You know, you think, well, the war's just happened. People want electricity. People want water. People want food. People want justice. It is this deep visceral need in these societies which when you work in this field, they truly want. And they, left to their own devices, have a difficult time achieving that in a timely fashion in a way. And it's like this great societal pent-up pressure. And that was true in Iraq from day one. The very first chance the Iraqis had in every capacity and in every forum to voice what their needs were, what their voices were. Yes, they wanted electricity, they wanted food, they wanted a bunch of things. They wanted justice. They wanted a system of accountability. And you know, they use slightly different phrases, but they would say, I had one judge say to me, I've read Justice Jackson's statements, and I want the rule of law. I want to emulate the model that he gave, and that's true. These are educated, literate people who understand that. The difference is, in World War II, in the middle of the war, one of the key war aims, one of the key objectives was to bring justice and to bring accountability. So you had a formal process. You had the UN War Crimes Commission collecting evidence and drafting a statute and working on those issues even during the middle of the conflict. Unfortunately, what we have today, as was earlier pointed out, is more of an ad hoc process where we always, it seems, have to play catch-up from the international community perspective and from the process of bringing the justice to the people that they just desperately need, because it's so important to ending the conflict, to societal restoration. All those things are not just words and concepts that we impose from the outside. That's why the Legal Affairs Subcommittee was set up in the very early days to begin to look at a statute. They took what had been done in the Rule of Law Project. They took what had been done in Newport, Rhode Island. They took what had been done other places, and they said, we want to adopt this. We want to change it. We want to make it our own. And they asked for assistance. It wasn't that assistance was simply crammed down their throat or that it was taken. They asked for assistance. And then that dialogue took a long time to work out. In the fall of 2003, for much of the fall, this was the dialogue. A back and forth of what is appropriate norms. How do we import these? The very fundamental decision, as has already been pointed out, of do we have a domestic process or an international process was made very early on by the Iraqis. They flat refused to say, we abdicate our responsibility. We want to build a new Iraq. They really did say that. And in discussions with Iraqis, I've often been reminded of our framers in our Declaration of Independence. Go back and read the document. It's this stirring statement of ideals and norms and values and what we want this country to be. In the very last sentence, our framers said, we pledge our lives, our fortunes, and our sacred honor to this set of principles. And the Iraqis that I worked with, these judges and these prosecutors and these defense counsel, have been no less noble in their aspirations. They have pleaded for assistance from all around the world, and many times the world has turned a blind ear. Governments around the world have refused to help and then turned around and criticized in public. I think that's morally wrong. If we want to live in a world where we truly have the rule of law reinforced across the board, then I believe we owe it to those people to help them. In December of 2003, by sheer coincidence, the statute was adopted and promulgated in a press conference by the Iraqis on the anniversary of the Universal Declaration of Human Rights, by sheer coincidence. And the Iraqis knew that. They picked up on it, and they said, what we're doing is in the finest traditions of human rights norms and restoring the rule of law to Iraq. Those weren't just words and concepts to them. The challenge was, as has been pointed out, but I want to emphasize this because it's a much more significant challenge than we can cavalierly talk about. The challenge of taking a well-developed legal system and fully importing international norms, international standards, the full range of crimes against humanity, war crimes, genocide law as it has evolved in the modern era, the challenge of importing that into a tightly woven, integrated legal system is enormously difficult. And again, I go back to my comments. I believe we owe the sovereign governments of the world, those of us who are in this community, assistance in doing that. What the Iraqis have done, and this needs to be said, what the Iraqis have done in building in these norms really sets the model for what every other country in the world is doing when they ratified the International Criminal Court statute, as the Brits have done. They are taking the full set of legal norms and building it in an integrated, holistic way into their justice system. That process is a lurching process. There's a lot of questions that come up. What's the relationship, for example, between an international process, which usually has a self-contained appeals process? There's an appeals chamber, it's a self-contained process. What's the relationship between our pre-existing appeals processes and this process? What's the relationship between this unique body set up to try these unique sets of crimes and these unique sets of circumstances and the ordinary criminal courts? What's the process for allocating concurrent jurisdiction? All these difficult questions that need to be resolved and were resolved. So I tell you, it's a sovereign right based on complementarity that will always be done against the backdrop of expectations of society. Of course, the international norm is that the tribunal process is independent and impartial. But it will always, as has been seen in the Milosevic case and in the Kirstich case and in the Hinga Norman case in Sierra Leone and the Charles Taylor trial, they will always exist in a political context. The challenge is, to coin the phrase, to quote, these courts are in the world but not of the world. They're in a political milieu, but they're not political bodies. They're not political instruments, and yet they exist in a political context. They survive in a political context. They're funded in a political context. The support for continuing that process comes from the people and the politicians who represent those people. I will tell you, in December of 2003, the very first group of Iraqis who saw that statute and reviewed it, we set up a collaborative dialogue with them to discuss and hash out and hear their concerns and hear their questions. As a matter of historical record, the first question they had, how do we set up, given the political pressures to do justice now, how do we set up a construct that is independent and impartial and capable of adjudicating without external political pressure? That was their first concern, and they grappled with that. And today they could still continue to grapple with that. They know justice. When you say to them, the rest of the world does not want to help you because you retain the death penalty in your sovereign system, that offends them. It offends them a great deal. I had a judge say to me, I am a judge, not a murderer. I know the law. I know to apply the law. Why don't the legal advisors in the rest of the world come and assist me in implementing the law properly in accordance with human rights? And I said, I don't know. Go ask them. But we're here to help. So let's focus on what we can do. I also want to emphasize the fact that when the statute was adopted, there were two very important, almost last-minute changes that had been discussed. One of them, of course, as has been pointed out, was the role of international advisors and international judges. A key topic of discussion in the lead-up to the statute allows international judges. And when the Iraqis went and said, we want international judges to come and sit with us, nations of the world, the governments of the world, turned their backs on them. The statute does not allow international advisors. It requires international advisors. So to say, well, the Iraqis just sort of set up their own closeted, contained process to do it their way and ignore international norms is simply not correct. They wanted assistance. They still want assistance because they want to do it right in accordance with international norms. The other change that was very important was, and this is a last-second sort of a drafting thing, in the concept between Arabic and English. The Arabic phrase was special court, which translated in English. And of course, that called, and I told you these things all happen in the milieu, the context, the backdrop of expectations and experience. The problem was, during the Ba'athist regime, there were many, many thousands of Iraqis executed with no trials as a result of a special court, a revolutionary court. In fact, that's one of the key issues in the Dujail trial today. Were there actual trials held for those 148 people who were executed? Very little evidence of that. So there was a last-minute name change in the statute that said, this is, in the early first statute, the Iraqi Special Tribunal for Crimes Against Humanity. Despite the fact that the jurisdiction, of course, included Iraqi crimes, crimes against humanity, genocide, and the full range of war crimes. And that was done deliberately by the Iraqis to distinguish this process from what had gone before. The challenge then, as it remains today, and I'll make two final points, is the challenge of taking international norms, building them into the domestic system in a way that still balances the domestic system. So that's what you've seen. There are still uniquely Iraqi characteristics of this process. For example, they knew that Milosevic and Sechel and others were obstructionist, very difficult defendants. But underlying Iraqi law allows the defendant the right to ask questions of the witnesses. They anticipated that was going to be a problem. But they were committed enough to their principles and to the rule of law to sustain that principle of underlying Iraqi law. I'll give you another example. In the courtroom today, there are civil lawyers representing those victims, straight out of Iraqi law. The role of the investigative judge, very different from the role in the ICTY and in the ICTR in Sierra Leone. They retain that role out of Iraqi law, even though in some sense it makes these cases more difficult. They retain that because they wanted to mesh those systems. And then my final point. And this is critically important to the rule of law process, and it was a critical concern of those judges from early on. In the ICTY context, we call it the crime base. Nobody doubts that huge ranges of crimes were committed. The evidence is overwhelming. The crime base is massive. There are documents all around the world that document that. The challenge, however, in accordance with the rule of law, is to take this crime base and apply the principles of personal responsibility to prove this case against this accused. In terms of the correct form of participation and how you charge that, how you prove that, the minutia of the elements. And I've worked with these judges many, many hours to tell you they have labored, they have sweated, they have researched, trying to apply the right body of international law to this body of crime so that what you get is an inverted pyramid. Huge amounts of crime, huge amounts of law, all the way down to one specific finding against one specific defendant. Thank you.
Thanks a lot. Paul Wolf.
Thanks. Good morning, everybody. First, I'd like to thank the organizers of this symposium, Professors Bassiouni, Scharf, Ellis, Chavez, and Newton, for inviting me. And I think it shows their open-mindedness to have invited someone with an opposing view, and I sincerely mean that. So who am I? I'm an attorney in private practice in Washington, D.C. I am not a member of the President's defense team, but I have provided assistance to Curtis Dobler and to Ramsey Clark, who are a part of that defense team. And it's really their perspective that I can share with you today. It's quite an impressive symposium. There are, I think, roughly 20 speakers. I'm the only person who is arguing from the position of the defense. And I have exactly 12 minutes, and I'm going to try to watch that as closely as I can. So there are way too many issues for me to address, and I'm going to try to stay focused. I will say that while many of the panelists are talking about the Iran-Iraq war in the 1980s, my comments are more focused towards what's happening today in Iraq. And I'll just cut to the chase, and I'll start out by making a proposal. The proposal has 3 parts. Number 1, the United States should apologize for the war in Iraq. Number 2, Saddam Hussein should be reinstated as president. And number 3, Saddam Hussein should restore order to Iraq. And he's the only person in the world who can do it. And the U.S. should get out of Iraq. And I hope that you'll think about that and take that seriously while I use the rest of my time to point out what I think is the main problem with the trial and the main issue that this symposium should address. And I'm happy to answer questions afterwards. I called my talk The Poisonous Precedent. And I think that the precedent that this tribunal is setting is the main issue. We're calling this the trial of the century. Well, what kind of a century is it going to be? Is this going to be a century of war? And I hope it's clear to everyone that Iraq did not have weapons of mass destruction. Iraq did not have a nuclear weapons program. Iraq was not supporting al-Qaeda. Iraq was not behind the attacks of September 11th. And in fact, Iraq had been blockaded for 12 years and could not threaten the United States in any way. In 1991, just after the first Gulf War, the United States and Iraq agreed to a ceasefire. Now, the terms of the ceasefire are set out in UN Resolution 687. Iraq did not violate those terms, and that ceasefire was still in force when the United States attacked Iraq in March of 2003. Now, under Chapter 7 of the UN Charter, only the Security Council can authorize military attacks to enforce UN resolutions. Otherwise, the use of military force is only permitted in self-defense. The Security Council did not authorize the U.S. attack on Iraq. And if you don't believe me, you can ask Vladimir Putin, you can ask Jacques Chirac, you can ask Jiang Zemin, the Chinese Prime Minister then. All 3 of those leaders opposed the U.S. attack. On March 5th, 2003, France, Germany, and Russia, they issued a joint statement vowing to block any UN resolution authorizing the use of force. Just 2 weeks later, America began the shock and awe bombing campaign. People claim that the UN Security Council authorized the shock and awe and the deaths of thousands of people. It didn't. Now, I'm speaking with a group of attorneys, and you know that international agreements are essentially contracts between states. So, just like any other contract, you look at the objective intent, the meeting of the minds. In this case, the parties to the contract are the members of the Security Council who signed Resolution 1441, which is the reason being given why this war is legal. 3 permanent members of the Security Council said that they never authorized the use of force. Russia, China, and France all could have vetoed that. John Negroponte, at the time he was the U.S. ambassador to the United Nations, he said, and I'll quote, that UN Resolution 1441 contained no hidden triggers and no automaticity with regard to the use of force. That's John Negroponte, and there's your objective intent with Resolution 1441. Of course, you can look at the plain language of the resolution. There's nothing about authorizing use of force. The words used are consequences and serious consequences, but it doesn't say anything about the United States enforcing that resolution. And then what happened? The United States invaded and occupied Iraq. It set up a new government, and it put the old government on trial. Not for weapons of mass destruction, not for violating the Nuclear Non-Proliferation Treaty, not for September 11th, not for violating any other UN Security Council resolution. And the president of Iraq was held for 2.5 years before he was charged with a crime. To charge him with a crime, the occupying power had to set up a special court with special new laws. And we're using that word special because everyone knows that that's a trigger word, because this is not permitted in international law. You can't set up a tribunal to try a specific group of people, even regardless of the fact that something like crime of a genocide I don't think even existed during the Iran-Iraq War. So my position is that the basis for the tribunal is not legitimate. It's rooted in an illegal war of aggression, and then everything else flows from that. But I will say that even if the war was legal, I don't think that the tribunal would have jurisdiction. And this applies to Afghanistan, and this applies to Guantanamo Bay. You know, this is in Congress right now being debated. And when was the last time that the winner of a war got to put the loser on trial? These ad hoc tribunals, these were done under the auspices of the United Nations, essentially, of other countries. And it just sets a terrible precedent to go back to the way things were done before the United Nations was created. We've had plenty of people talk about the statute that created this tribunal. I'll comment that it was written in English. It was signed by Paul Bremer. He doesn't even understand Arabic. It was translated into Arabic at a later time. It does not refer to Islamic law. Iraq is an Islamic country. If you understand anything about Islam, religion and law are very closely related. And I mean, I just think that it's funny that the Iraqi Governing Council got to enact that statute. And there's not a lot of funny things about Iraq. It's a terrible tragedy. It's a disaster, really. But, you know, for the Iraqi Governing Council, installed by the U.S. government, to get sovereignty for just one day to enact this act, so that the Iraqi people could enact it themselves. And then, you know, the United States takes back the sovereignty. Then eventually there were elections. When America was ready to have elections, there were elections. The president's name wasn't on the ballot. So we'll really never know, despite what you say, we'll never know if Saddam Hussein was a popular president or not, because he couldn't get on the ballot. Now, maybe that sounds strange to you, and it sounds maybe a little bit unusual to do something like that, but the Iraqi people should have had the option to keep their president, and that could have happened. Instead, what has happened, Sunni has been pitted against Shia, Arab against Kurd, and my belief is that the government that's in place right now wouldn't last one day if the U.S. military wasn't there. Like I said, I have very little time left, and I'll leave it to the other panelists to really describe the details, due process issues with the Dujail trial. I will mention that the defense wrote several lengthy motions challenging the legitimacy of the court, asking for the removal of a hostile judge, and several other things. But they might as well just drop them at the judge's feet. This is what the process server has to do sometimes when the defendant doesn't want to get served papers. The court wouldn't accept them. The court wouldn't rule on them, and to this day has not done anything other than orally deny the motions. So, you know, how can you really defend a case if you can't file motions in the case? I have English translations of some of these motions with me, and they're also online at international.lawyers.org, where we have some information about the case. I think that one thing that we can all agree on is that this trial is a circus. And what is the point of having a trial if the outcome has been predetermined? And if the purpose is an educative value, I've heard this phrase many times, and it's not to determine facts, then it's really an exercise in propaganda. And the Soviets did this. The Soviets had show trials. Some people complaining, the president's making outbursts during the trial. Well, it wasn't his idea to televise the trial. And if you don't like the drama, then it's an issue to take up with the U.S. military who produce and edit the tape that you see. That brings me to my main point. What is the real purpose of the trial? Maybe, the court is looking for reasons to justify the war in Iraq. Maybe that's what this is about. We're looking back to Dujail. We're looking back to events that happened in the Iran-Iraq war, which was 25 years ago. And incidentally, I think it's ironic that that was when the U.S. supported Iraq. It was when these events took place. And we have to go all the way back 25 years to find reasons to put these people on trial. Did the use of chemical weapons in the Iran-Iraq war, does that justify the American invasion and occupation of Iraq that's going on now? Does it prove that the Iraq had weapons of mass destruction? Is this related at all to what is going on in Iraq today? I'll conclude my remarks, I guess, because I see that I'm almost out of time, by saying that I think that the problem here is that the case sets a very bad precedent for the future. The expression that comes from Nuremberg is poisoning the chalice. We're poisoning, the chalice that we're passing on to future generations who want to create a system of international law. Here, a superpower attacks a helpless country, invades it, occupies it, kills thousands of people, and then puts the losing government on trial on TV. And that should be opposed by anybody who is an advocate for world peace. And I hope that you actually do consider the proposal that I made, reinstate the president, and just get out of there. If you want the next century to be a century of peace, where the United Nations is an effective instrument for preventing war, and that was the reason the United Nations was created, then you have to oppose this war and you have to oppose this trial. Thank you.
Thank you. We'll take questions. And we also have questions coming from upstairs in the other room. In the back. Do we have a microphone?
Hi. Thank you all for this very informative information. My name is Besma Fakhri. I'm a president of an Iraqi women organization. I came here to listen to the legal precedents or what's going on about Saddam's, not about political speech. And I thought that's what was started, It's not political. It's supposed to be about what's going on in Saddam's trial. And I'm surprised at Mr. Paul Wolf's comments about bringing back Saddam. Apparently, Mr. Wolf, you didn't live in Iraq 35 years under Saddam. You didn't lose a relative. You didn't lose a family member. You didn't lose your freedom to speak about Saddam. Saddam, when he was there, he was doing all these crimes undercover. No media, no human rights talk about it. Now you're talking about bringing him back. Saddam, whatever going on in Iraq now, his people is doing it. People are supporting him because he has billions of dollars outside Iraq to support him and go with this propaganda. If I want to listen to this political stuff, I can go to all these emails, I can go through all these websites. They have a lot of them, but not here. Here we are talking about, I'm not a lawyer, but here we are here to talk about the justice for the victims that they want, their voices never heard. And, of course, fairness for the Saddam and his regime. So this is a precedent for the whole region, for the whole world, to listen that dictatorship has an end, shouldn't be reinstate him again to slaughter whatever left from the Iraqi people. Thank you.
Are you going to take another question? I can comment. I really do think that the jurisdictional argument is an absolutely solid argument. And that's what the President has been saying himself. The court is illegitimate. It can be said in very complex legalese, and believe me, we have a 100-page motion that's been written setting out a very solid legal basis for why this court does not have jurisdiction. I just don't speak that way. So as far as the due process issues, I do agree with you on that. I think that it's important that however we feel about someone, these trials are always difficult, that we do have to uphold the rule of law, and I'm completely on board with that. And I'm just leaving that to other speakers to address the, the smaller details, which are important. But for me, I think the jurisdiction and the fact that we're doing this at all is the strongest legal argument.
Thank you.
Questions from upstairs.
Is there another question from the room? This room?
Hi, Paul. Greg McNeil. My question for you is, if we accept what you've set forth, all of the sort of the political arguments about the legitimacy of going in, there still stands the allegations of the crimes against Saddam, the allegations against him. What judicial remedy would you propose for the alleged victims? What different source of justice would you propose? Because it seems like you have a very different opinion than the rest of the panel. So I'm curious what your remedy would be for the alleged atrocities.
Well, I think that if this case were removed to the UN, I guess that would be my second position. If you don't want to restore the president to power and try to bring everything back to normal, that incidentally, that's really, I know that that's a politically charged statement, but I really don't think that there's any way out, and I really don't see the government in Iraq now being a strong government that's gaining in legitimacy. I think that the UN could do something like this, or if not the UN, a real international group. And I don't mean that you find some people from other countries, maybe from other Arab states, to sit on this tribunal. But this has to be, this is not like the Sierra Leone, Rwanda, and Yugoslavia trials. And I think you have to ask, why aren't other countries on board with this? And maybe there are people here who know that. If this is legitimate, why is the United States once again doing this all by ourselves? And we're saying that the Iraqi people are doing it, and this is a sovereign act by the Iraqi people. I don't even know how to address that.
I think we have some other comments from the panel.
Can I add one, two things?
There's an information operation that goes on in Iraq by the insurgency that says Saddam is going to come back to power, so you better stay on the fence, you better not help the government. And it's a part of any war, these information operations. And unfortunately, the story that gets put out there, which is just purely false, is that the Americans are going to somehow force the Iraqis to bring Saddam back. Never going to happen. And anybody who's been burdened with experience of having actually been in Iraq can tell you the Iraqi people would absolutely, 100%, doesn't matter, across the board, would oppose that. And certainly there's no one is going to oppose that. I doubt that even China, France, or Russia, who were mentioned earlier, would support that. The world wouldn't tolerate it. Iraq wouldn't tolerate it. It's never going to happen. And it shouldn't happen. I mean, we're talking about a guy who did have some elections. If you've ever seen an Iraqi ballot from the elections, it says, I want Saddam Hussein to be president of Iraq, and you've got a check mark. There's no other option. And there's a number on the ballot so they can check how you voted. It's not really an election. It's a mind control, or it's an experiment in oppression. But anyone who can advocate putting someone back in power who was responsible for a genocide, who was responsible for killing hundreds and hundreds of thousands of his own citizens. We can see the violence that's going on in Iraq now, but Iraq has been an extremely, exceedingly violent place for the past 30 years. It's just that you didn't see it when busloads of children and women were brought out into the desert and buried over the course of Saddam's regime. And the genocide, the Anfal campaign had, one of the tools that it used was these prohibited areas. And if you were in one of these prohibited areas, you were subject to being killed without question. Man, woman, child, animals, any living thing in these prohibited areas was subject to just instant execution. Now, after the Anfal campaign ended, and the Anfal campaign was just a military campaign to enforce that rule didn't change. There was an amnesty, but still, if you were caught in a prohibited area, you were still subject to being killed. And if you go to that area of Iraq and look above this green line that has been protected by the no-fly zone of the British and the Americans since the 90s, you see rebuilding and people living there, et cetera. But if you look in the area below that, you see nothing. There was nothing. Because that policy, that genocidal policy of Saddam, never stopped until the invasion. So this is supposed to be about preparing for the mother of all trials, so I'll bring it back to that. When we were preparing for the mother of all trials and we were up in that area of the Kurdish region, I can tell you that the people had suffered, and the people were very grateful that they had been saved from that suffering.
Professor Bassiouni,
Yeah,
quick comment.
I realize, of course, that what Paul Hoffman said immediately brought up the level of internal pressure and boiling of the blood in many of us here. But if you distinguish the issues of, did the United States have the legitimate authority to resort to armed force to invade Iraq and to do a regime change, leave that aside for the time being. There's probably some merit in whether the U.S. had such authority, whether its assumptions were correct. All of this is valid. Now, look at it from a purely legal point of view. As the ambassador said, Iraq had a series of constitutions. When the Saddam and Ba'ath regime came, the first thing they did was to eliminate that constitution, amend it, and draft a constitution which, among others, gave power to the Supreme Revolutionary Council and gave Saddam absolute immunity, as well as the members of the Supreme Revolutionary Council. Now, by its very nature, when you have a dictatorial regime that does that, you have a choice of either being a purely, strictly formalist and say, well, I'm going to look at the last constitution in effect, and if that's the constitution, I go with it, or you ask the question, if you go to substance, was it substantively correct for the Saddam Ba'athist revolutionary power to change the constitution and take on exclusive dictatorial powers? If you accept that proposition, then you return back to the last constitution that is in place. And under the last constitution that is in place, you're not going to have this absolute immunity. Number two, please bear in mind, Iraq ratified the Genocide Convention, it ratified the Geneva Conventions, and therefore the head of state is responsible, irrespective of whether he is head of state, past head of state, or future head of state. He is responsible under the Genocide Convention and under the Geneva Conventions, and could be prosecuted in an Iraqi court for these crimes, which are crimes as well under Iraqi law.
Thanks, Professor.
No, wait, I have to say one more thing. It's a technical point. Iraqi is a very positivistic legal system. One of its earlier requirements is that even it ratified an international treaty, there had to be a national law that would promulgate it. There was no national law promulgating either the genocide or the Geneva Conventions. But the military law incorporated the provisions of the Geneva Conventions. And so there might be a technical, formalistic question about the principles of legality, but not a substantive legal one.
Thank you. We have a lot of questions on the fairness of the trial, which will be addressed in the next panels. And those questions came from upstairs, so I thank them for sending them. Michael Sharp is asking me to end the session.
It's because we have C-SPAN only to 1:45. 8:45, and we have to keep things really going. So what we'll do is take a 10-minute break till 20 after, and start right at 20 after, and we'll start with our next session. But thank you all for a great day.